Hey everybody, back for part 2 of preparing for passing of a spouse. This was brought to me a couple of months ago and I've created a full class for this. So you're getting a sneak peek to the class that's rolling out next month. So part 2, we're going to focus in on the estate planning. When we're preparing for a spouse to pass, we do need to have that estate plan in order. So let's start with choose a plan. If you don't have documentation, you either have to have a will-based plan or a trust-based plan, okay? For the most part, wills are best for most. It's for simple estates, single state real estate, especially here in Arizona. We allow what's called beneficiary deeds here in Arizona, but there are many states that do not allow beneficiary deeds. So those states would require a trust to be able to pass real estate to the next generation, okay? So single state real estate, no business ownership, simple family dynamics, and less than the lifetime estate tax exemption, which right now is $12 million per person. I will tell you, for a couple, if you're over 12 million, you probably should start thinking about a trust-based plan. Proper titling and beneficiaries is very important, and honestly, it's very easy to create a will-based plan with all those wonderful websites that are out there, LegalZoom.com and USLegalForms.com. There's plenty of websites like that. Will-based plans are perfectly fine using those websites, okay? Trust-based plans, on the other hand, this is for the larger estates. If you have real estate in multiple states, you've got family businesses that are going to live on after you, difficult family dynamics, maybe a special needs child. These are all going to require trust-based plans, especially when you have real estate in a state that doesn't allow a beneficiary deed. So if you have a trust, you have to remember to fund that trust. That sounds silly, but you will end up in probate, or your heirs will end up in probate if you don't properly fund that trust. That means everything except your IRA and Roth account should be owned by that trust. So the other part of this is understanding how property transfers. So if we're losing a spouse, if we're preparing for the loss of spouse, whether it's because of something we know or something that we're just preparing for the inevitable at some point in the future, okay? We need to understand how stuff transfers. Proper titling becomes the most important priority, because in the legal realm, titling, the ownership documents of anything, comes first. If you own your house jointly with a spouse and one spouse passes away, there's no probate, there's no documentation needed, there's still an owner alive. It's the same thing for a bank account. If there's two people that own a bank account and one person passes away, there's still an owner alive. Everything's fine, okay? No probate, no documentation, no nothing. Then beneficiary designations are number 2, okay? So first, make sure you own everything jointly with your spouse, okay? Because this is about what if we lose one of our spouses. If we lose a spouse, we got to have a joint ownership on everything we can have joint ownership, which means everything except your Roth accounts and your IRA accounts. That's where beneficiaries come in. Spouses should be the primary beneficiary on each other's accounts. So if you have an IRA or a Roth account, you make your spouse the beneficiary. That's very important. It makes it very seamless, very quick and easy, okay? Titling, ownership documents, beneficiaries take priority number 2. If your trust says that your IRA goes to your cousin, but your beneficiary on that IRA says it goes to your spouse, it's going to your spouse, okay? No matter what your trust or will says, your beneficiary is a higher priority on that legal totem pole, okay? So beneficiaries must be listed properly. Reviewing all of your accounts, making sure these beneficiaries are listed properly before somebody passes is really important. Then there's the will or the trust, okay? You're going to have a will in case you forget anything above. If you forget the proper titling, if you forget the proper beneficiaries, that's when the will comes in. The trust is there. If you choose a trust-based plan, the trust is going to own everything that it can. So proper titling, yeah, it's going to be titled in the name of the trust. All your real estate will be, your cars, your bank accounts, everything except your IRA. So that's why the trust will take priority, because it leapfrogs everything by being the owner of everything. Okay, but if you don't do that work, because your lawyer can't, you have to go into your bank account, you have to go and talk to all your investment companies, you have to go in and get all this stuff fixed. The title company can change the ownership of the house to the trust, but they're not going to be able to change the bank account, the car, or anything else. All right. Then gifts. Gifts are by far the lowest on the priority totem pole. So be very careful. If gifting early in life causes strife, you need to be careful, all right? Because if your trust or your will contradicts what you did before you passed away, you might run into some arguments after you're gone. So be careful about the gifting that you do. So the documents that you need to make sure you have, if you have a will-based plan, you need to have the last will and testament, which says what personal property goes to who. If you have minor children, then then it names who's in charge of those minor children. The living will says pull the plug or don't pull the plug. All the life-sustaining treatments that we have, it gives us a nice list of choices on those. And then you have your medical and financial power of attorneys. Those are the documents you need in a will-based plan. Then you've got the trust-based plan. Almost the same documents. The only difference is instead of the last will and testament, you have a revocable living trust, typically. There's plenty of other fancy trusts out there, but most of us just get a revocable living trust. And then there's a pour-over will. You know, the only reason for the pour-over will is if you don't do things properly, and your heirs then have to go into probate. Okay, in the previous video, I talked about a client who the husband had sat down at the table and said, I'm hiding a lot of stuff from both of you. His own wife of 50 plus years, he flat out admitted he's hiding stuff. Well, she had to go into probate even though she had a trust. She found over $100,000 worth of treasury bills that were in his name with no beneficiary on them. She had a trust-based plan, but because those things weren't owned by the trust or had any beneficiaries on them, she had to go into the court system just to get approval to get that transferred to her. Okay, so even if you have a trust, the work's not done. You have to make sure that all the accounts are pointed to the trust, either owned by the trust or the beneficiary ends up being the trust. And then the same documents as the will-based plan, you need the living will to pull the plug, not pull the plug type stuff, and the medical and financial power of attorneys. Some of the resources that are great in this part of dealing with the passing of a spouse, LegalZoom.com. My mother-in-law, we had to refresh and update her power of attorney several times. We just jumped on LegalZoom, printed them out, $25, $35, something like that. Quick, easy place. You don't have to go meet with an attorney and spend hundreds of dollars. You can just download the forms you need and sign them. It's really easy. State Attorney General has in Arizona, many states have this. The State Attorney General will actually put medical power of attorneys and the living will on their website because these are state-by-state documents. Good financial advisor is always going to help out with this. Somebody to lean on, especially if the person that is passing is the one that is the financial person, the one that pays the bills and manages the money. A good financial advisor is always somebody to lean on that can help you through things, okay? And then attorney with a good financial advisor can always be good because 99% of attorneys give the rest of them a bad name. So always have somebody else keeping an eye on them as well, all right? I hope this helps. There's a lot more to this. We got one more video coming on preparing for the passing of a spouse. But if you have questions or need help with anything, you can always contact us. If there's a topic you want me to create a class on, or even just a little mini 10-20-minute video, I can always do it. I love the suggestions. That's where this one came from. So that's why we're kind of cutting it up and putting out the test videos now for you. Let us know if we can help. Give us a call, shoot us an email, subscribe, send it to friends. We'll see you next week. Thank you.